Welcome everyone. We are now back with our ABCs of the FCRA Part 2, Important Terms, Definition, and Standards video within our advanced video series. As always, I'm your course instructor, Aaron Swift. I'm the CEO and managing partner of Swift Law North. Let's jump right into our agenda as we always do. Again, we're talking about important terms, standards, and definitions under the Fair Credit Reporting Act. So first, we're going to talk about the distinction between consumer report, credit report disclosure. We talked about that in our basic video series. We're going to go a little bit deeper here. It is not a strict liability statute as opposed to the FDCPA. We're going to talk about how and why. Talk about the different standards as it applies to inaccuracies. And lastly, it's a civil lawsuit with private right of action. We'll talk about that with best practices. Okay, so we talked about, and again, the basic video series about credit reports an interchangeable use term. It doesn't actually have much significance under the law because under the law, there's either consumer reports or consumer disclosures. And in general, the FCRA requires an underlying consumer disclosure or report in most circumstances. Actually, it's a consumer report in most circumstances because remember, that's the information that is compiled from your credit file, credit history into a report, and that's reported out to someone or multiple people. There are inquiries that's published to someone else. That makes it a consumer report of information. A consumer disclosure is information that comes to the consumer. So that's if you request your own credit reports via like annualcreditreport.com, that's a consumer disclosure. The FCRA's protections require the information that's inaccurate or incomplete, inconsistent in material ways that is found in an actual consumer report or consumer disclosure, not a reseller report, not your Credit Karma disclosure, not your app-based Experian disclosure that you see on an app. Those aren't actual consumer reports or disclosures. They have no weight under the law. And again, publication is key. That's what makes it a report. So that can be a hard or soft inquiry. We talked about the different versions of those again in the basic video series, but publication is key. The bad information basically has to go somewhere. Um, there are reseller reports that can sometimes have liability. In most cases, that's going to be a tri-merge report for a mortgage lending transaction. I'm going to go into too much detail here, but just know it's basically consumer reports from annualcreditreport.com, from the bureaus themselves, the ones that are used in lending transactions, the Credit Karma and the others. No. Okay. So we talked about the FDCPA being a strict liability statute. And I even went into detail about mens rea and actus rea. Here, you do need a mens rea, which again is an intent for certain types of violations under the FCRA, the Fair Credit Reporting Act. Again, intent and knowledge do matter here, unlike the FDCPA. So under the FCRA, the Fair Credit Reporting Act, you can have negligent violations. That's when they violated the standard of care that results in damages. It's usually thought to be a non-intentional action. So if a credit reporting agency reports bad information, may or may not fix it, but didn't do so recklessly or willfully, and we're going to talk about what that means here in a moment, then it's going to be considered a negligent violation. Then you can contrast that with a willful violation. This takes recklessness or gross negligent wanton conduct. There's a standard called a wanton disregard for someone's rights. And sometimes it can even be purposeful conduct. So, at some point, if a credit reporting agency keeps ignoring very valid objective disputes, at some point their conduct will be held to be reckless or willful. And then it's not just a negligent violation. It's a willful violation, and very importantly, that opens them up to punitive damages and statutory damages. We'll talk about that later when we talk about the powers of these two statutes more, and actually in our pro video series. Okay, so let's talk about what it takes to actually be inaccurate under the statute. The FCRA requires reasonable procedures to assure the maximum possible accuracy of the information and data that it reports. That sounds great, right? Maximum possible accuracy. What could be could be more accurate than that? You'd think it's 100%. Um, But it's not, because it's really reasonable procedures to assure. And when you're talking about billions of bits of information, mistakes are made. But what does that mean in practice? We're looking for objective inaccuracies. The reporting of a discharged debt after bankruptcy with a balance, the reporting of a debt that's not owed by someone because it may be identity theft or fraud. There's also a substandard where something can be not a substandard like it's a bad thing, a subset of this legal standard that says there can be technically accurate cases, but in which the information is materially misleading. The classic example of this is when you go to trade in a car at a dealership and you owed a note. So you're trading in a car you still owed money on. And what the dealership is supposed to do is pay off that note as part of your transaction. And then, of course, now you're paying on the new vehicle. Well, what happens if the dealership fails to do that? So now it's out of the consumer's hands. The consumer doesn't even know that he or she, quote, missed a payment because they're not even obligated to pay anymore. Now they signed a new contract, a new retail installment contract that had an assignment with a new a new note. Um, and that new note was supposed to partially pay off the old one, and now it's owed going forward. So some courts have held that that's a different standard because, yes, it may be technically accurate that the consumer's old loan was 30 days late or 60 days late, however late, but it's materially misleading to hold that against the consumer because at that point it wasn't in their hands anymore. So again, we're looking major, cases are always going to be looking for objective inaccuracies, but we can take cases where there's technical accuracy, but if it's materially misleading. So what does this mean? Well, first of all, just like the FDCPA, the FCRA allows a consumer to sue the credit reporting agencies and furnishers in a civil action. Some more information, see our pro videos 3 and 4, but just understand that consumers can sue under this law. And just like under the FDCPA that provides different types of damages, and the defendants or bad guys would have to pay the prevailing consumers fees and costs. So hopefully now we kind of get you to a point where you've understood the who, what, and why of the FCRA. Now you're understanding some important terms, definition, standards, so you're better prepared to deal with actors in this space. You're better prepared to look over credit reports. You're going to be better prepared to understand what's maybe not accurate or what's technically accurate. Now, if you're in a better position to spot those errors, please reach out. Again, those errors can lead to litigation where you're going to get debt forgiveness in a lot of cases, trade line deletion, potentially thousands of dollars, and there's little to no risk because the fees and costs are paid by the bad guys. For more educational content, as always, please visit www.consumerlaw101.com. And for litigation information, including if you have errors on credit reports, please visit www.swiftlawnorth.com. Thank you.